Most attorneys I talk to about thought leadership have the same problem. They're invisible in the marketplace to everyone except their current clients and referral sources. They're not invisible in the marketplace because they lack experience or expertise or wisdom or knowledge. They're invisible because of three gaps between what they know and what the market thinks they know based on the thought leadership they produce or lack thereof. In my experience, attorneys at firms of all sizes and types can experience one or more of these three gaps at the same time. Today, I'm going to walk you through these three gaps. I'm also going to tell you why most attorneys do not know which gap they're suffering from and what they can do about it. The first gap is the coverage gap. With the coverage gap, an attorney has deep expertise and experience and wisdom regarding the areas of law they practice and the industries they serve, but they've published little, if any, thought leadership content about either. So when someone searches for content or information regarding those topics, they don't find that attorney, they find somebody else. Now think about that for a second and how frustrating that can be. An attorney spends years, maybe decades, building knowledge in a very specific area of law or a very particular niche of an industry. They've handled dozens, if not hundreds of matters. They know all the nuances that less tenured attorneys would miss entirely. But there's no thought leadership content out there with their name on it, or there's very little content. And without that content, their knowledge, their wisdom, their experience, their expertise, it's invisible. It only surfaces when someone who already knows them reaches out to them to discuss a particular issue. The coverage gap is the most expensive one because attorneys are losing opportunities they do not know even existed. For example, a GC at a company that just got hit with an NLRB charge is looking for an analysis regarding how to handle those kinds of charges. A CFO dealing with a novel cross-border tax issue looks for someone who has written about that issue or at least cross-border tax structures previously. An attorney can have the knowledge and wisdom and expertise that these would-be clients are looking for, but if they're not producing content, then these would-be clients aren't reading it, and thus they're not reaching out to them. They're instead reaching out to the attorneys who have produced this kind of thought leadership content based on what those GC have been able to find online. The problem for attorneys is that the coverage gap is by definition invisible. Attorneys can't see the searches in which they did not turn up. The second gap is the frequency gap. Unfortunately for attorneys and all professional service providers, publishing thought leadership twice or three times a year does not build authority. It builds the impression that you are publishing thought leadership occasionally. This distinction matters more than most attorneys realize. Authority is not built upon a single thought leadership article. Authority is built on a pattern, a series of thought leadership articles. It's what happens when someone sees an attorney's name enough times on thought leadership content regarding topics within their areas of practice or the industries they serve, that they start to associate the attorney with their practice areas and or the industries that they serve. The threshold that I have seen work consistently for attorneys who want to produce thought leadership in a way that creates an air of authority and puts them out into the marketplace in front of target audiences, that threshold I've seen work consistently is about 8 to 12 substantive pieces of thought leadership per year. That's roughly one per month, give or take. Below that, an attorney isn't really building a presence in the marketplace. They're making cameos in the marketplace. There's a big difference between an attorney who shows up in their target audience's feed once in a while and one who is consistently sharing analysis about the issues that their target audiences are facing. One of those attorneys is going to be top of mind when a referral opportunity comes up or when a client is looking for help regarding certain issues. The other one is going to be remembered only if someone already knows them. Now, I understand why attorneys fall into the frequency gap. Writing takes time. Billable client work is always going to take priority. And there isn't always an ROI on a single piece of thought leadership content. In fact, it's rare to get an ROI from a single piece of thought leadership content. But the ROI on a year of publishing thought leadership content consistently, the ROI on a decade of publishing thought leadership content consistently compounds. It's not linear. The 10th thought leadership article that you produce this year is going to do more for your visibility and the building of your authority than the first 1 or 2 or 3 articles this year combined. The third gap is the audience gap, which is the one that I see most often among attorneys who are somewhat consistently producing thought leadership content. The audience gap revolves around this truism that writing for everyone is writing for no one. I know that sounds simple, but when I look at most attorney-authored thought leadership content, it's written at a level of generality that makes it really hard for anyone to say, hey, this was written for me and people in my industry dealing with the kinds of issues that I am dealing with. The attorneys who generate actual referrals from their content, who generate actual leads from their content, write for one particular person, the ideal client that they want to attract. The test I use for determining whether a piece of thought leadership content does not fall prey to the audience gap is whether someone receiving the article would say to themselves, I know exactly who to send this to. When a GC reads a particular thought leadership article, it thinks to themselves, hey, this is exactly the kind of issue that we're dealing with here. That tells you that the article was written for someone in particular. When a fellow attorney at the author's firm or another attorney at a different firm reads that attorney's thought leadership article and thinks, I know exactly who needs to read this, that article was written for someone in particular. Thought leadership content written with someone in particular in mind is a potent marketing and business development tool because it's specific enough to be useful. And when a piece of content is useful, it shows to the audience that the person writing it is likely to be useful based on the experience they have, the knowledge and wisdom they have that's captured in the thought leadership content. The audience gap is why attorneys can publish relatively consistently, get decent engagement, and still not see new matters come in the door based on their content. Their thought leadership content is being read by too broad an audience to trigger inquiries from or referrals to their ideal clients. I want to mention one last thing regarding thought leadership gaps that attorneys might be facing. It's important that they use LinkedIn and other feedback they receive from their target audiences concerning their content as a focus group. The posts that get the most engagement from your network on LinkedIn, or that get the most responses when it's blasted out over email, or the most comments when it's published in a forum that allows comments, that is all telling you something. That's a signal. That feedback, those comments are telling you what your audience wants to read about in your thought leadership. That feedback is helping you understand which of your topics are landing with your audience, which angles you take regarding those topics are landing with your audience, and which questions your audience is grappling with. Obviously, if they're responding to thought leadership content regarding specific questions, specific issues, then that's going to give you a sense that the questions and issues that you are tackling are exactly what your audiences are thinking about. Most attorneys ignore these signals entirely. They write what they feel is important to them. They write what they think is important to their target audiences or what they like to write about. They don't always factor in feedback that is directly from their audience telling them exactly what they should produce more of. The most effective thought leadership content is the kind that speaks to the issues and questions that target audiences are dealing with and wrestling with at the moment. So those are the three gaps that attorneys tend to face in their thought leadership efforts: the coverage gap, the frequency gap, and the audience gap. Most attorneys encounter at least one. A lot have two, and some even have three at the same time. But here's the thing: you can't close a gap that you don't know exists, nor that you've measured to see just how significant of a gap it might be. That's why my colleagues and I at the law firm Edge Hill Service have built a free tool that shows you exactly what your thought leadership gaps are. In under 3 minutes, with no phone call or live chat necessary, you'll be able to discover where your thought leadership gaps are. It's called the Opportunity Finder. You can find it at lawfirmedgehillservice.com. I'll put the link to the Opportunity Finder in the description. If you found this discussion useful, there's more where it came from. Subscribe so you can regularly get more best practices regarding thought leadership delivered right to you. And while you're at it, check out lawfirmedgehillservice.com. We have more than 500 videos, blog posts, and podcast episodes chock full of best practices for thought leadership.